We'll make a start now. Welcome, if you're joining us, great to have you with us for the Mills and Reeve Immigration Update webinar. Really good to see you. What are we going to be doing this morning? We've actually got a really packed agenda this morning. Lots of things have been going on. We'll aim to finish shortly before 11 a.m. so we can get to the next meetings that we've all got. But yeah, it's been a really interesting, fluid time on the immigration front. So lots to be looking at. What are we going to be doing this morning? We're going to have a look back at what has happened essentially since our last webinar back in September 2022. So principally looking at changes that affect sponsor-related issues, particularly the skilled worker category. Quite a few changes there actually of practical relevance around things like start dates, salary calculations, leave issues. So Mark is going to be taking us through some of those, as well as some practical points around the latest on visa processing times, which I'm sure many of us have found to be significant practical issues recently. We'll then have a bit of a roundup of a few other bits and pieces and a focus section where there's a couple of issues that we've been advising on, picking up on recently that we thought we'd share a few thoughts on in that focus session. And then I'll have a bit of a look forward to what could be on the horizon for 2023. We're clearly in quite interesting times in lots of ways. We've got a skills shortage across the economy, low skills, high skills alike, a real need for growth. I think everyone would accept, and immigration is one of the levers that can be used to achieve growth, but all within the political context, there's still a desire to reduce net migration, more employers needing to become sponsors, access the global labour market for lots of reasons, and more cross-border and hybrid working post-COVID, and all of those complications that those bring. So against that backdrop, we're going to have a bit of a think around, well, what are the themes and the possible changes looking ahead for 2023 that could be affecting us as employers. As always, if you've got any questions, do pop them in the Q&A feed, not the chat, please. We can't monitor two at once very easily, but the Q&A feed, and we'll see if we can pick up some of those at the end, picking up on the common themes that are coming through there, if we can, those questions. So without further ado, let's kick off with our look back, particularly sponsor changes, and Mark's going to take us through that.
Thank you, Alex, and good morning, everyone. So as Alex has noted there, just going to take you through some of the kind of significant changes in relation to sponsorship of migrant workers that we've seen over the past few months. And the first thing we're going to look at are changes to how start dates operate and some of the practicalities around your obligations as sponsors. By way of context, and many of you will be aware of this, when you are sponsoring a migrant worker, one of the things that you have to do on the certificate of sponsorship is insert an intended start date. Now, obviously, it's not possible for you to be completely accurate when doing so, and you're not expected to be completely accurate. Certain things, such as visa processing times, for example, are outside of your control. But the idea is that you are putting in the realistic date that you are expecting this sponsored worker to commence working with you. And within the context of that, there is a requirement that the individual actually commences their work with you within 28 days. Now, those 28 days can run from one of several different trigger dates. And just to explore those a little bit for context, the trigger dates in question are either the date that is listed on the certificate of sponsorship, so that date that you've put in there as the intended start date, or the date from which the visa itself becomes valid, or the date on which the individual is made aware of their visa decision, so that it's actually communicated to them that the visa has been granted. Whichever of those options is the latest date will be the relevant trigger date in any given scenario, and that's where the 28 days runs from. Now, just to give a practical example, if you have inserted on a certificate of sponsorship a start date of the 1st of January and the visa is actually granted on the 10th of January, but the decision is communicated, it's sent through to the individual on the 11th of January. It's the 11th of January that's the final date there, that's the latest date, and that's where the 28 days then runs from. Once you've got your trigger date in any given scenario, The key point is if the individual does not commence working for you within the 28 days from that trigger date, then you as sponsors are required to report the fact that they failed to commence work within the 28 days. And actually you have to cease sponsorship at that point because they have failed to commence work within 28 days. Now that's the general rule. That has been the position and continues to be the position. There is and has been an exemption to that, what is termed an acceptable reason for failure to comply with the 28-day rule, which is if an individual is contractually obliged to complete a notice period with a previous employer, they are permitted to go beyond that 28 days. So you can delay the start date beyond 28 days if it's because of a notice period that they're seeing out. The change that we've had recently, and a welcome change at that, is that we actually now have more of these acceptable reasons. So in addition to being able to delay beyond 28 days because of a notice period, we can now also delay beyond 28 days due to one of the three reasons that we've listed there for you. So if the delay relates to travel disruption because of a natural disaster, military conflict, or pandemic, then that will be permissible. If it relates to exit visas or administrative issues associated, then that will be permissible. And the context there is, of course, some countries require their residents to obtain an exit visa when they are leaving the country to go and live elsewhere. Or if the delay relates to illness, bereavement, or other compelling circumstances. So those are additional acceptable reasons, which obviously broadens the scope of possibility to delay beyond the 28-day rule. And then crucially, those additional reasons actually are not exhaustive. So the Home Office have further stated that we have these additional reasons now, but this is not an exhaustive list. And we will look at each case and judge it on its merits. I think in practice, that's going to be more relevant to the final point, the point around compelling circumstances, because obviously that's slightly more nebulous than perhaps travel disruption due to a pandemic. But the point is, it will be dealt with on a case-by-case basis. And the way that actually works is you, as the sponsor, will still be required to report the fact that the delay has taken place. So you have to go into the sponsor management system, make a report stating that they've not complied with the 28 days rule, we're delaying the start date beyond the 28 days, and provide a justification for doing so. So one of these acceptable reasons. That will then obviously appear on the Home Office's system, and they can then judge that on its merits. Now, it is worth noting, just because you've made a report doesn't necessarily guarantee that the report will be accepted. There is a possibility that the Home Office will come back and say, actually, we don't accept that this delay is permissible. We don't class this as an acceptable reason, and therefore sponsorship has to end. But the point is, you are providing all of the information, and then the case can be judged in isolation on its own merits. And just an extra practical point on that, a final point there. Obviously, whatever the reason is in any given circumstance, you will need to provide some sort of evidence relating to it. So if, for example, the delay was due to an illness and the individual was hospitalized for a period, some formal documentation to recognize that. And then moving forward, a couple of minor but equally significant changes to start dates. Previously, it has been the case that even when the 28-day rule is complied with, those delays still need to be reported on the SMS. So essentially, the certificate of sponsorship is updated to show what the correct date actually is. By way of example, if you had an individual with a start date of the 1st of February, but they actually commenced work on the 7th of February, you would go in, obviously that's permitted, that's within 28 days, you would go into the system and you would say the new start date is the 7th of February. That is no longer required. So that additional administrative step has been done away with, which obviously is significant in the sense that it is very rare that an individual does in practice commence date on the exact date that you've set on the certificate of sponsorship. And so normally it would be the case that actually pretty much every sponsored worker start date needs to be updated. That's no longer the case. If it's within the 28 days, that's fine. You don't need to report it at all. And then finally, on start dates, we have had confirmation from the Home Office within the guidance that individuals can actually commence their work as soon as the visa is granted. So even if the visa is granted before the start date as currently listed on the certificate of sponsorship, they are permitted to commence work, and equally no report needs to be made in relation to that earlier start date. Using the previous example, if you've put start date of the 1st of February, the visa's granted on the 20th of January, the individual actually enters the UK on the 21st of January. They can commence work on the 21st, 22nd, 23rd, whatever it might be. They don't have to wait for the 1st of Feb. So some welcome changes there in terms of start dates, and hopefully a lot of that will be helpful kind of on the ground, because it in practice gives employers more flexibility and less need to report. Looking now at some headlines in terms of some of the other changes we've seen, we've had now a change to the way in which defined certificate of sponsorship submissions are completed. Many of you will be aware defined certificates of sponsorship are those which are required when you are sponsoring an individual who is coming from outside of the UK. You basically complete a two-step process. The first thing you do when you're sponsoring someone from outside of the UK is you go into the SMS and you request a defined certificate, which involves inserting all the information about the role itself. So job title, job description, what the SOC code is, what the salary level will be. The Home Office then consider that. In most cases, they will grant it to you. It will then be available on the license. And then the second step is you go back into the license, you access the granted certificate, and you insert all of the personal information about the individual who will actually be sponsored, and then you can assign the certificate. Previously, the requirement to provide information about the weekly hours that will be worked by the individual was part of that second step. So it wasn't included in the job information, it was included in the personal information, as it were. That has now changed. You now deal with it in the first step. And the significance there is that part of what the Home Office are doing after that first step is they're assessing eligibility based on the information you provide. As a lot of you will know, the salary level, the going rate for the relevant salary level, can be prorated based on working hours. And so in many cases, it's not actually possible to make an assessment of eligibility if the Home Office don't know what the weekly working hours will be, because how can they prorate it? So they've made that change, and hopefully that will mean that actually we don't see as many requests coming through. And we've had examples of this with several of our clients, requests coming back to say, well, actually, on the face of it, it doesn't seem that the requirements are met. And then when we've provided the weekly hours, it's very clear that actually they are, because it's being prorated. So that hopefully will either completely disappear or at least be reduced, which will in turn reduce delays. So another welcome change. One practical point on this, it's obviously conceivable that where you are at the point of requesting a defined certificate, the details of employment might not be fully agreed at that time. And so specifically, if the working hours are still yet to be agreed, what you should be doing as best practice is inserting what you would expect the weekly working hours to be based on the type of role, the department that the individual will be based in, so on and so forth, and putting that on the certificate. Obviously, that may be easy in some circumstances. If the business operates the same working hours across the board, very straightforward. If not, just base it on analogous roles and what your normal expectation would be. In circumstances where that then subsequently changes, it's simply a case of adding a sponsor note to the certificate of sponsorship after it's been assigned to say the weekly hours have now been agreed and they are no longer, 37 weekly working hours as we stated on the COS, they're now 39, for example. Moving on to the next change, salary calculations. It has previously been the case that the only salary that could be counted towards meeting the salary threshold was the basic gross annual salary. That was kind of clarified and simplified in December 2020 with the introduction of the skilled worker route, and that has remained the case until recently. We now have the option also to include guaranteed payments, provided that those guaranteed payments are treated in the same way as basic salary for the purposes of tax, national insurance, and pensions. And we've put an example there. A good example here would be a guaranteed payment of a London waiting, which is treated exactly the same way for tax NI as the basic salary would be. It's still the case that non-guaranteed payments can't be included. So bonuses, for example, still can't be included in salary calculations. But this addition of guaranteed payments just offers a bit more flexibility in terms of how we can meet that salary threshold in any given case. A practical point on this, evidence of the fact that those particular guaranteed payments, whatever they might be, are treated the same as basic salary will need to be provided in the form of pay slips. Pay slips essentially need to show that tax deductions are being taken from the guaranteed payments in the same way that they would salaried payment, the basic salary, for example. And then the final main change on this slide, unpaid leave. Worth noting that it has been and remains the case that individuals who are sponsored are not permitted to take more than 4 weeks unpaid leave in any calendar year. That is a sponsorship requirement. It applies even if the employer and the employee would theoretically be happy to allow more than 4 weeks. There are some specific exemptions to this rule. The most obvious would be parental leave. But generally speaking, an individual can't take more than 4 weeks unpaid leave in a calendar year. The change that we've seen is we now have an additional exemption to that rule, which is that more than 4 weeks will be permissible if the reason is for compelling and compassionate circumstances. Now, this obviously, as I was outlining in relation to the 28-day rule and delays, this is obviously dealt with on a case-by-case basis. There's no hard and fast rule about what will be a compelling or compassionate circumstance. So it's again the case that, you know, a report will need to be made and the Home Office will need to consider that. But the general point here is that, again, we have just a bit more scope in terms of what is permissible, and a bit more flexibility in terms of the type of things that the Home Office will say, well, okay, we accept this, and you don't have to cease sponsorship in this particular case. And then some final headline changes. I'm not going to dwell on either of these because they are very circumstance specific, but we have seen an update to the guidance in terms of reductions in pay. So it is now the case that a temporary drop in pay, that is a drop that obviously would take the individual below the normal salary threshold, that will be permissible if it is specifically due to individual health reasons, or a phased return to work after ill health. When relying on this, an operational health assessment will be required as evidence, and it is still the case that even though the overall salary can drop below the permitted level, the individual must remain paid at or above the required hourly rate throughout. So really what we're talking about here are cases where, due to ill health, an individual is perhaps dropping down their hours or making a phased return to work. And then the final point, the seasonal worker scheme has expanded. So this scheme relates, as the name suggests, to seasonal workers, and now included within that seasonal worker definition are SOC codes which relate to poultry production. Specifically, this is these SOC codes have been added purely through the period 18th of October to 31st of December each year. Obviously, the idea being in the run-up to Christmas, more workers are needed in those SOC codes. Moving forward then, looking at some more significant changes, we've had a recent and potentially far-reaching change to the global business mobility route. Now, just for context and by way of reminder, perhaps, the global business mobility route replaced what was the Tier 2 intra-company transfer senior or specialist worker route now operates in the place of intra-company transfer. So what we're talking about here are individuals who are transferring from one group company overseas to a UK business that has a common owner. Now, the immigration skills charge, which is the charge that you will all be familiar with, which is payable in relation to those individuals you are sponsoring and which is paid at the point of assigning a certificate of sponsorship, now no longer applies to senior or specialist workers, provided they are EU nationals transferring from the EU to the UK business within the same overall group, and where they're only going to be here for 3 years. So the certificate of sponsorship itself cannot exceed 3 years. Now, I realize that's a lot of qualifications, and perhaps it seems that actually this isn't going to apply broadly, but it is a significant change in the sense that, first of all, this is quite a large saving for businesses that are making use of the global mobility senior or specialist worker route. We're talking about generally a saving of £3,000 per sponsored worker, assuming they are working for 3 years. And secondly, and I think perhaps more significantly, is the possibility that this might extend beyond just EU nationals or beyond just the 3-year point, or even beyond just the global business mobility senior or specialist worker. What we have here is an example of the Home Office saying, well, in these particular circumstances, we are going to do away with the immigration skills charge. How this goes, and this is purely speculation on my part, but how this goes may then inform how they deal with the immigration skills charge for other routes moving forward. So obviously, those who are impacted with this will welcome the change, but potentially watch this space for other categories moving forward. And then the final point from me before I hand you back to Alex is just a quick look at processing times for visas. Now, as many of you will be aware, the Home Office processing times have been a bit all over the place. Not really through any fault of their own, but they've been a bit all over the place for essentially 3 years now. We had obviously the impact of the pandemic, followed by and kind of incorporated with the end of the Brexit transition period and an influx of applicants from the EU. And then when everything seemed to be coming back to normal a little bit, we had the invasion of Ukraine and the Home Office redirecting a lot of their resources into dealing with applications from Ukrainian nationals. All of that to say, it's been very difficult for employers, employees, and indeed for ourselves to really nail down what a processing time is going to be in any given circumstance. The good news is we're pretty much back to normal. It seems like the Home Office have been working very hard over the past month or so to clear whatever backlog they were dealing with. And certainly since the beginning of 2023, we are seeing that the normal visa processing times are pretty much there across the board. To give a particular example, in the case of skilled worker visa applications submitted from within the UK are taking up to 8 weeks. That's the normal service standard. And those submitted from outside of the UK, so entry clearance applications, are taking up to 3 weeks, again, at the normal service standard. Now, of course, although that's all good news, there is still a level of fluctuation there to be expected, as there will always be. But that works both ways. And one practical example I wanted to give is we've had multiple examples over the past couple of weeks of individuals who are applying from within the UK, who are making use of the UK ID app, which we've referenced in previous sessions. It will be available to certain individuals in the UK where they've previously enrolled biometrics as part of a prior visa application. So for example, if you have a worker who's already sponsored by another employer who is transferring to you, so they're doing a change of employment application, they'll be able to use the ID app. And what we've been seeing is for those applicants, the decisions are coming back in a number of days rather than a number of weeks. And that's actually in the context of applications being made without a priority service payment. These are normal applications made in country using the app, coming back extremely quickly. Now, I'm not saying that's the norm, but certainly things seem to be trending in the right direction. Final point on processing times, the priority services are back and fully up and running now. So that's a priority service of £500 for a decision in 10 working days, or a super priority service of £800 for a next day decision. Often worthwhile using just so you can have a bit more control and clarity over exactly how long the application is going to take, and particularly if the applicant is applying from within the country but is unable to use the ID app, they have to attend a biometric appointment, for example. If that could take up to 8 weeks and you want it to be quicker, a payment of £500 just to speed that up is potentially worthwhile. So I'll hand you back to Alex to look at a bit of a roundup.
Great, thanks, Mark. So before we go on to a bit of a look ahead, I thought we'd just have a quick roundup of a few other bits and pieces. There's been an extension to the number of nationalities that are classified as non-visa nationals, so people that can come to the UK without a visa in advance to enter as a visitor for up to 6 months. The countries are there on the slide, perhaps not of huge significance to most of us, but I thought I'd flag for sake of completeness. Do remember the China COVID testing requirements that have now kicked in if you are recruiting or indeed sponsoring somebody from a visa who's coming from China, with the easing of the Chinese borders. All arrivals from China need to have a negative test in order to board a flight, and there's obviously been, I think in the news this morning, further details on the explosion really of COVID in China. So build that in and make sure that step is sorted out if you're recruiting somebody who's coming from China. Quite an interesting point that you may have picked up in the news, third one on there, relating to the EU settlement scheme and the High Court ruling in December last year, which some staff possibly may have mentioned to you. It certainly received quite a bit of publicity. This came out of a judicial review application by an organisation called the Independent Monitoring Authority against the Home Office, essentially saying that the requirement under the EU settlement scheme for people who've got pre-settled status to have to apply for settled status after 5 years in order to become lawfully resident after that period, that is unlawful. And you'll recall that you get pre-settled status initially, and then once you've got 5 years continuous residence as an EU national in the UK, or indeed a family member of one, you can then apply for settled status, so an indefinite, unrestricted, essentially, right to stay in the UK. And it's quite interesting because they report by the 3 million group. So there's a population the size of Leeds, Liverpool, Manchester and Birmingham combined who could potentially lose the right to remain in the UK if they didn't take this step. Bit technical, but it all comes back to the withdrawal agreement and what was intended or agreed as part of that. And what the High Court said was, well, you can only lose rights as a citizen if those circumstances are set out in the withdrawal agreement and the expiry of pre-settled status is not set out in the withdrawal agreement. That's something, if you like, the UK has layered on top. And so this requirement is unlawful. Where does that leave us in practical terms? I think the UK government is going to appeal this by all accounts. I would say clearly in practical terms it still apply if you are an EU national who is coming up to being able to get settled status. It obviously makes sense to do that to ensure you get your status confirmed, benefit from all the rights that are associated with that. I think running a kind of a principled objection and not applying, which I've heard some people talk about, is a dangerous strategy to take. And I would suggest that whatever the outcome of this, there's going to have to be a pragmatic fix and new guidance and possibly secondary legislation at some point. So I don't think in practical terms at the moment it makes a huge difference, but an interesting point relating to the application of the withdrawal agreement. Final point on there, applications by overstayers. This is applications by somebody whose permission to remain in the UK has expired. That can arise in various circumstances. There are limited grounds or limited circumstances when somebody can lodge an application as an overstayer. And you've got to be quite careful in this area for lots of reasons. Generally, if you're an overstayer, I think getting some advice is a sensible course of action to take. But the reasons or the circumstances where you can do that have been extended to include applications that are rejected, not just those that are refused. And essentially that means that if there's been a practical cock-up, if you like, as part of the application process, so for example, there's been a problem with payment of the application fee or missing paperwork, there is some scope to apply as an overstayer rather than not have that option and all the problems that go with that. So you might have some staff occasionally in that situation, and it's worth flagging to them, getting some advice and the slightly broader spectrum of circumstances there. Great, so I wanted to then move on to a bit of a focus session on a couple of issues that I think are topical, either have been raised with us quite a bit or which are of interest at this time, and just think about those before we then look ahead to what's on the horizon for this year. A couple of areas I wanted to touch on. The first on the left there is a switching from the graduate route or graduate visa to a skilled worker visa. So we've been getting quite a lot of questions around people who are recruiting somebody who's got a graduate route visa. That's the post-study work visa at the moment that somebody can get for 2 years or 3 years, depending on the level of study that they've been doing, and gives them essentially an unrestricted right to work. They can work for whoever they want for the period of that visa. They don't have to be sponsored. They don't have to meet salary thresholds, all those sorts of things. So it gives a lot of flexibility, and lots of international students are coming obviously out with this visa following the conclusion of their studies. But many of them will say to an employer, may have said to you, well, we're quite interested. We'd like to be sponsored, please, for a skilled worker visa. Please, can you facilitate this and make this happen for us? The reason from their perspective for wanting to do that is because time spent in the skilled worker route counts towards your 5 years continuous residence for settlement or indefinite leave to remain. Time spent in the graduate route does not. So you can see it's a big thing for them to want to get on this skilled worker track and start the clock running on that. So the question is, well, do you have to agree that? You know, what's the right approach there? Short answer is no, you don't have to agree that. The person has got a right to remain in the UK and work for you. You are under no obligation to have to progress an alternative visa application sponsorship under the skilled worker route. And many sponsors think actually we don't want to, we want to kind of try before we buy. It's sometimes put, and we don't want the costs like the immigration skills charge Mark mentioned, the administration associated with it, the risks potentially with sponsorship until we have to have those. But I think particularly at the moment and the current labour market and how hot it is, the key issue here is around, I think, recruitment and retention. So we're certainly aware of a number of businesses that are willing to sponsor immediately and switch the person from graduate to skilled worker because it's an attractive thing to do. It's part of the selling of them as a business in terms of recruitment and retention. That, I would suggest, is going to be the key issue for most of you. Do you need to do this in your sector in order to recruit and keep the staff that you want, or will they find another employer and sponsor who's prepared to be more amenable to that and enable that switch for them? Moving to the blob on the right, we're obviously in challenging economic times, and I think certainly some employers are looking at redundancy, restructure. Just a bit of a red flag on this, that if you have got staff who are sponsored for visas in the mix, you need to think about some extra issues around that. There's often an interplay between the immigration rules, the sponsorship guidance, and employment law considerations around implementing a fair restructure and redundancy process. And those don't always sit that easily or jigsaw that easily together. The most obvious example being in a redundancy situation, you've got the obligation to look for alternative employment for somebody, but you can see that if that person is sponsored, let's say for a skilled worker visa, you can't just slot them into that role, applying the usual employment principles. Is the role that you would slot them into in the same SOC code? If it's not, they'd obviously have to make a fresh visa application. If it is in the same SOC code, you're going to have to report a change of circumstances around things like job title, job location, a change of core responsibilities, those kinds of things. Are the eligibility requirements met? In the new alternative role, are the salary requirements going to be met? Is it in a qualifying SOC code? It usually will be, I would think, but certainly the salary point is something to check. So you just have to essentially think, okay, have we got anybody sponsored, affected by this redundancy restructure? And what do we then have to layer over our processes to make sure that we cover off both of the employment law fairness issues and the immigration compliance issues? It's not as complex as it used to be under the old Tier 2 general system, where you had the resident labour market test in play, which really created problems in this sort of scenario. But you've still got to work those points through, make sure that you build them in, and perhaps even consider as part of a redundancy exercise, well, do you want to offer some sort of particular package or support for somebody on a visa who is being made redundant? There are sometimes little things that you can do to make things a bit more straightforward for them, give them a better shot at finding alternative sponsor and having a bit more time before their leave in the UK is curtailed, because obviously it has particularly significant implications for somebody on a visa and their family indeed. If they are made redundant, it can be a very, very difficult and stressful situation. So a couple of issues there to be thinking about that are topical. What I now wanted to do before we spend a little bit of time, Mark will be sort of feeding through the questions, looking for the questions and seeing what we can pick up from those. But what have we got on the horizon for 2023? We're at the start of a new year. What can we expect over the next 12 months or so? And I mentioned some of the context at the beginning, but it is clearly very relevant. We've got an economic downturn, and possibly a recession is going to be biting at some point, the worst, I think, since 2008 in terms of the economy, and potentially more long-lasting. But that's unusually in set in the context of a skills shortage of both of the high-skilled roles, labour for those roles, and indeed the lower-skilled roles like agriculture, care home workers, or deemed lower-skilled roles, such as those. And there was a speech that Tony Danker, the Director General of the CBI, gave towards the end of last year, flagging these points, saying we've got these skill shortages, we need an increase in economic migration, it's a barrier to growth. He called for fixed term visas. I'm not sure there's such a thing as a non-fixed term visa, but anyway, there we go. An expansion of the shortage occupation list, a holistic approach. And I think the government probably recognises those things, but we've got this political dynamic of the aim to bring down net migration. There's some really interesting stats up there, actually. So to the year September 2023, 2.6 million visas were granted, but interestingly, 48% of those were visitor visas, 23% was study. So, you're looking at sort of 3/4 there. Only 15% of those were work visas, of around half of which were skilled worker visas. So you've got an immigration system at the moment where lots of people are coming into the UK, but actually not that many, apparently, for sort of economic reasons coming into work. And I wonder if that is something the government is going to be looking at quite carefully, given that their aim is to reduce net migration. And the figures for that to June last year were 504,000 net migration, the highest figure for a long time, arguably affected by unique factors like Ukraine, Hong Kong, Afghanistan, but something the government says it wants to cut. And Suella Braverman, the Home Secretary, has said she wants to get the figure down to the 100,000 figure that David Cameron talked about many years ago. We've got a significant increase in sponsors because of the ending of free movement. And we've also got this new way of working, global mobility, hybrid, cross-border working. A City of London Corporation report looked at this and was saying we're just not really set up for it. Businesses at the moment are just having to navigate this new landscape. This sort of global mobility was at the periphery before COVID, but it's now at the centre, and we've still not really got a coherent regulatory framework here, and visas, I think, are part of that. So that's the context that we're in, quite testing times. Where does that take us in terms of what could be cropping up? I mean, a few brief thoughts before I turn to some more significant points. What could be the areas of focus? I think certainly the agricultural sector will be one area of focus. Mark already mentioned a change around poultry. I think there is just a shortage across the piece for that. And I think we can expect to see more flexibility for more sectors, I would suggest, in the coming year. Perhaps more of interest to many of us is, I wonder if there could be an increase in the salary threshold, so both the general threshold and the going rate threshold, given what we have been seeing with inflation and the annual rate of pay growth. So currently 6.4%, 7.2% in the private sector. Yes, that's a 2.6% cut in real terms, but still obviously really significant increases, leaving those sort of thresholds a little bit behind the curve, really. So it may well be that over the coming months, we could see those salary thresholds reviewed and possibly notched up, which may have implications for some of us where salaries aren't necessarily going up, but we see the threshold go up and that affects eligibility for sponsorship. A shortage occupation list review. This is a list of roles where we're deemed to have a shortage of labour in the UK for them. The Migration Advisory Committee, which advises the government, was commissioned to do a report in August last year on reviewing it for the skilled worker category. That was put on hold, quote, pending clarification of the government's priorities surrounding the skilled worker route, which some might say says quite a lot, but it could well be that that will come to the fore again, work restart on that. And as I said at the beginning, I wonder whether there could be much more of a focus here in policy terms on trying to pull a lever of work-related economic migration. So getting people in that route, making that more straightforward, perhaps less costly for businesses, while tackling some of those that might be seen as more passive routes, or perhaps less good in economic terms. Controversially, that would be possibly the student route may come under attack. For example, that's an obvious thing the government seems to be gunning for, appropriate use of that category, relevant for those of us that are at universities. I think right to work compliance at the bottom left there is an interesting one to be thinking about. There are lots more sponsors. Resources have clearly been stretched at the Home Office. There haven't been as many compliance audits as there used to be, but the government sponsorship roadmap still confirms that compliance visits remain a priority. And as Ukraine calms down, it could well be we see more of a focus on those sorts of visits, but particularly I would suggest if you're in a sector that might be regarded as higher risk. So I suggest that sectors that are recruiting people in deemed lower skilled roles, so perhaps typically some of your agricultural, food processing sectors, for example, where there are lots of people coming in on visas at the moment, but the government seems a little bit reluctant sometimes to be easily facilitating that. You could be possibly facing scrutiny, but across the board, we could be having more audits. Are you in good shape? Do you need to do your own audits? Do you need updated policies, procedures? What about training from a friendly Mills and Reeve lawyer? All those kinds of things to get yourself in good order. Trade agreements is something I think to be thinking about. So the government is perhaps more slowly than it would have liked to agreeing bilateral trade deals. And we've already seen last year some immigration consequences flow from those, particularly in the youth mobility routes, so younger people coming to the UK to work on a temporary basis, possibly service supply, intra-company transfer, so global mobility type routes. We might see more carve-outs, more bilateral arrangements with immigration considerations flowing from that as the months unfold. And a bit of a warning, final one on this slide, if you are somebody who has a business with British citizens travelling to the EU, which many of us do, or indeed we might be going there for holidays at some point this year. During this year, the EU is introducing a system for monitoring entry and exit to the EU, and they hope to have that apparently up and running fully by November of this year. There's going to be like a travel authorization fee, some sort of electronic application to have to make to travel to the EU. Watch this space for more details on that, but we might have even more administration to have to encounter there, whilst the EU wants to make sure that the 90 and 180 days time spent in the EU or in the Schengen area is being properly adhered to by people who are entering. A couple of areas to touch on in a little bit more detail. The first is the electronic travel authorizations, which again is potentially significant, I think, particularly for those of us that have people coming into the UK as visitors quite often. Certainly the higher education sector, I think, would fall into that bracket. The UK is going to be introducing an electronic travel authorization scheme, again, by Q3 of this year is the plan, which is going to be in place for all travellers who aren't British or Irish nationals and don't otherwise have a visa. So that would include, for example, obviously the EU, USA, Canada, Australia, New Zealand, Hong Kong, all the usual suspects where people typically will be coming to the UK from in relatively large numbers. The idea is it's an online application, biometric details have to be provided, a small fee has to be paid, travel details provided, suitability questions answered. There's talk about it being a 15-minute application, which probably means a couple of hours in practice, and short processing times of 48 to 72 hours. It's not a visa, it's just a digital approval, which then authorizes the person to get on the plane, if you like, and come to the UK. When they're then at entry clearance in the UK, if they're a non-visa national, they would still have to be granted entry as a visitor, established at the border that they are entering as a visitor. That substantive point remains the same, but you'll have this additional layer of procedure kicking it into play as well. For some sectors, that could be quite useful, possibly, in terms of having some degree of control, perhaps, or a bit more control over people coming into the UK as visitors that you're hosting, but something to keep an eye on. This is all part of the digitisation of the UK border, which is on schedule, apparently, for completion by 2025. And then what about hybrid working? I think this is a big one for this year, and this is probably something that lots of you have been grappling with, this disconnect, if you like, between the immigration system, which seems to essentially work on the basis that everyone clocks in and clocks out of a factory, if you like. That's not how modern work is, particularly in the sort of post-pandemic age. And yet we haven't really got sponsor guidance at the moment, which is up to date with that model of working and managing those issues and different places of work. And there's quite a lot of commentary out there which suggests that employers and sponsors should be quite cautious. Certainly, if you phone up the business help desk, always got to be cautious because you might get 3 different answers from 3 different calls if you do that. But if you do that, they would tend to adopt a very conservative and sometimes come out with some slightly unusual comments around this, so be cautious there. But how should we be dealing with work locations and reporting in this hybrid age? You've got to remember that during an audit and a compliance visit, the Home Office may ask to interview your sponsored staff, and if they are currently residing in the Orkney or something, because that's where they're working from remotely and that's not clear on the sponsor management system, you could be facing some difficult questions there. I think we can say there is flexibility at the moment. I think really the main address that they're working at, their main place of work, should be the work address that goes on the certificate of sponsorship. And if somebody is working sort of occasionally at home or some of the time from home, there's ambiguity around whether or not to report that as well. My view is, in general, making a report on that sort of point, there's no harm done. It's providing clarity and certainty around what the actual work location setup is, but we haven't really got clear guidance on that. Really, what you're having to do is still identify the main work location. I think what you do have to think about is the monitoring duties. So people who are working remotely on a regular basis, how are you able to meet your monitoring and reporting duties? Are you properly tracking absences? How do you know if the person goes AWOL for 10 working days, which is a trigger to have to make a report? Do you have mechanisms for people to check in to make sure they are still working? We will all have those, but just making sure they are clear and well understood is important. There might be something here, I think, around policies and procedures, perhaps a clear remote working policy, being clear to migrants and communication. This is what you must do. This is what's expected of you if you're working remotely, to help you as the employer and sponsor meet your obligations. Been some talk I was reading about of a digital nomad visa. Sounds a bit exotic for remote workers. I'm pretty doubtful whether there's anything in that. I can't really see how that works. But I would hope, and I think expect, that at some point this year, I would think we will get some updated sponsor guidance, I think, which will give us a bit more clarity around this issue and how we should be administering this as sponsors and the reporting we should be making with this new age of work. Good. So that's all I wanted to touch on in terms of that look ahead. As I said, there's lots going on, interesting times. I think we could see quite a few changes over the next 12 months or so. We've got 5 minutes or so for questions before we try and finish at 10:55. So Mark, I don't know whether there's anything you picked up from the feed in terms of themes that we could try and answer.
Yeah, absolutely. So we've had a lot of questions about what types of unpaid leave actually are permissible. So I just wanted to actually clarify exactly what we're talking about here. So types of leave that actually won't have any impact on that 4 week in any calendar year requirement that I spoke about earlier are statutory maternity leave, statutory paternity leave, parental leave, shared parental leave, adoption leave, sick leave, any leave any leave due to taking part in a legally organized industrial action, or in fact any leave related to assisting with international humanitarian or environmental crisis. So those types of leave are all permitted and don't count towards the 4 weeks that we were talking about. And then obviously, just to clarify that point and bring the whole thing full circle, it's then the case that any leave beyond 4 weeks that don't fall within one of those categories will theoretically not be permitted unless compelling circumstances apply. And that's where we get to the point about reporting those particular compelling circumstances. Some other themes and clarifications that I picked up on through the questions there. So first of all, just to clarify, in terms of the point around priority payments for visa processing times, had a couple of questions that mentioned the priority service being limited in terms of the amount of slots you can get. Just to clarify that point, what we're talking about in terms of the priority payments, the £500 payment or the £800 payment for the visa decision, is in relation to the application itself. There is then separately the sponsor priority option in terms of both pre-license applications and post-license applications. So for example, if you're applying as a sponsor to increase your amount of certificates of sponsorship, those priority services are limited, particularly in the example I've just given. There's 60 slots a day, and generally they fill up within sort of a minute or two of 9 o'clock. And one of the questions on that point specifically asked if we think this is going to change anytime soon. The unfortunate answer is no, I don't think it will. The reality is that the Home Office just don't seem to have capacity to deal with any more than that. And also sponsors want things dealt with quickly. So many people are trying to use those services. So that's probably here to stay. We had a couple of questions on the salary reporting as well. So first and foremost, just to confirm, there is no requirement to report an increase in salary. So where an individual is already meeting the requirements and their salary increases, you don't need to report that. And specifically, there was a question around kind of the interplay there between basic pay and then the guaranteed payments that I was discussing. If it's the case that the basic pay is already satisfactory and the individual is already sponsored, the fact that you now can include guaranteed pay doesn't matter. You don't need to now go in and report that change. And also just to clarify that when we're talking about prorating salaries, and the point I was making around confirming the amount of working hours on the certificate of sponsorship, the salary level that you are putting on the certificate of sponsorship is the actual salary that the individual will be paid. So you can't put the full-time equivalent on the certificate of sponsorship. If a person is working 0.5 FTE, you put their exact salary on the certificate of sponsorship, not the 1 FTE salary equivalent. Alex, I don't know if you've had a chance to look at anything.
Follow up on that as well, and to pick up on a question that's arisen there. You've got to be very careful when making salary calculations for eligibility for somebody who is working on a part-time basis. Put very simply, the person must always be paid in terms of their actual gross salary at or above the general salary threshold that applies. So the salary that applies for the option that they're getting the points under. So under option A, the 25,600, you can never prorate that to account for part-time hours. So the person must always be paid at least 25.6 if you're going to sponsor them, even if they're going to be working on a part-time basis. You can prorate to work out whether the going rate threshold salary is met, but as I said, it's always subject to being above the general salary threshold floor. That is an area where I've seen over the years a number of people make mistakes, and essentially they'll sponsor and employ somebody without meeting the salary thresholds. Common problem areas are obviously applications for flexible working, returners from maternity leave, where you think, well, surely we can just prorate everything and everything's fine. No, you can't. You still have to make sure the general salary threshold is actually paid to the person in terms of their actual earnings. Good. I think that was probably all of the main themes from the questions. So we have a lot of people on the webinar, so we're not able to cover all of the questions that are raised, but I think we have picked out the main themes. Just leaves it for me to say thanks very much for joining us. Hope you found it useful. We'll have another of these in a few months' time after, no doubt, some changes in the spring. That's a typical time of change on the immigration front. Do contact your usual M&R contact if you got any questions, if we can help in any way, day-to-day advice, or if you'd like some help with an audit or policies or procedures, or just giving you more support, whether as a level 1 user on your system or anything else. We're always very happy to help. But thanks very much for joining us. It's been great to have you with us. I hopefully see you or speak to you at some point soon. Many thanks.